Courtroom. Morning session begins. Clerk says, "All rise." Court is now in session. The Honorable Judge Elizabeth Carter presiding. Judge says, "You may be seated. We are here today for the criminal trial of the state versus Jason Miller, charged with armed robbery. Is the prosecution ready?" Prosecutor says, "Ready, Your Honor." Judge says, "Is the defense ready?" Defense attorney says, "Ready, Your Honor." Judge says, "Proceed with your opening statements." Prosecutor says, "Thank you, Your Honor." On the night of March 17th, at approximately 11:40 p.m., the defendant, Jason Miller, walked into a local convenience store in downtown Chicago. He was armed, masked, and aggressive. He demanded cash at gunpoint, threatened the clerk, and walked away with over $4,000 from the register. He left behind a terrified victim and a discarded ski mask later found with his fingerprints. Prosecutor says, "The evidence is clear. The victim will testify. Surveillance footage confirms it. Fingerprints on the weapon and the mask link directly to Mr. Miller. This man walked in with a weapon and left with stolen money, violating the law and putting a life in danger. We will prove his guilt beyond a shadow of a doubt." Judge says, "Thank you, defense. Your opening remarks." Defense attorney says, "Thank you, Your Honor." Ladies and gentlemen, what the prosecution wants you to believe is based on circumstantial evidence. My client, Jason Miller, has no prior convictions. His fingerprints being found on a ski mask proves nothing. He worked at the same store just 6 months earlier and had access to storage. There's no direct evidence placing him at the scene at the time of the robbery. No DNA, no confirmed witness identification. We urge the court to evaluate all facts before making a judgment. Judge says, "Very well. Prosecution may call its first witness." Prosecutor says, "The people call Mr. Daniel Reyes to the stand." Clerk says, "Do you swear to tell the truth, the whole truth and nothing but the truth?" Daniel says, "I do." Prosecutor says, "Mr. Reyes, can you tell the court what happened on the night of March 17th? Daniel says, "I was working the night shift. Around 11:40 p.m., a man came in wearing a black hoodie and a ski mask. He pulled out a gun and pointed it at my face. He told me to open the register and not to move. He kept yelling, and I was shaking. I gave him the money. He took everything and ran out." Prosecutor says, "Could you see his face?" Daniel says, "No, he was wearing a full ski mask." Prosecutor says, "Did you notice anything distinctive?" Daniel says, "His voice. It was deep and had a slight rasp. He also had a tattoo visible on his wrist, looked like some kind of flame design." Prosecutor says, "Thank you. No further questions." Judge says, "Defense, your cross." Defense attorney says, "Mr. Reyes, you say the man wore a ski mask. So, you didn't actually see his face?" Daniel says, "No." Defense attorney says, "And yet you're certain he had a tattoo?" Daniel says, "I saw it when he adjusted the mask. It was quick, but I saw it." Defense attorney says, "So, under extreme stress, you remember a tattoo shown for just a second?" Daniel says, "Yes, it was memorable." Defense attorney says, "No more questions." Prosecutor says, "We call Jessica Palmer to the stand." Clerk says, "Do you swear to tell the truth?" Jessica says, "I do." Prosecutor says, "Miss Palmer, were you near the convenience store on March 17th? Jessica says, "Yes, I live in the building next door. I was walking home." Prosecutor says, "What did you see?" Jessica says, "I saw a man running out of the store, holding a black bag. He got into a gray sedan and drove off. I saw part of the license plate ended with 6-8-9. Prosecutor says, "Was the man masked?" Jessica says, "Yes, but he had a flame tattoo on his wrist. I remember distinctly because it looked like the one my ex had." Prosecutor says, "Thank you. No further questions." Defense attorney says, "Miss Palmer, how far were you from the man?" Jessica says, "Maybe 20 feet. Defense attorney says, It was dark. Yes, Jessica says. Street lights were on. Defense attorney says, can you be 100% sure you saw a flame tattoo and not something else? Jessica says, I believe what I saw. Defense attorney says, belief is not certainty. No further questions. Prosecutor says, the people called Detective Marlon Hayes. Prosecutor says, Detective, what did your investigation uncover? Detective Hayes says, we reviewed footage from the store. It shows a man entering at 11:39 p.m., brandishing a weapon, and threatening the clerk. Although masked, the suspect's height, build, and movement pattern matched the defendant. We found a discarded ski mask with traces of DNA and fingerprints belonging to Mr. Miller. Also, a vehicle registered in his name matches the description given by a witness. Prosecutor says, were there any other suspects? Detective Hayes says, no. All evidence points to Mr. Miller? Judge says, defense. Your cross. Defense attorney says, did you find the weapon? Detective Hayes says, no. The weapon was never recovered. Defense attorney says, is it possible someone else used Mr. Miller's car? Detective Hayes says, possible, but unlikely. Defense attorney says, possible nonetheless. Detective Hayes says, yes. Defense attorney says, the defense calls Jason Miller. Clerk says, do you swear to tell the truth? Jason says, I do. Defense attorney says, Jason, were you involved in the robbery? Jason says, no, absolutely not. Defense attorney says, where were you that night? Jason says, at home. I was with my girlfriend. We watched a movie, had dinner. I never left the apartment. Defense attorney says, did you ever own a ski mask? Jason says, yes, from when I worked the night shift at the same store last year. It was in my storage unit. Could have been stolen. Defense attorney says, did you commit this crime? Jason says, no. Prosecutor says, Mr. Miller, isn't it true you have a flame tattoo on your right wrist? Jason says, yes. Prosecutor says, the same tattoo both witnesses mentioned seeing. Jason says, lots of people have tattoos. Prosecutor says, no further questions. Prosecutor says, ladies and gentlemen, the evidence is overwhelming. Fingerprints, vehicle description, tattoo. Witnesses saw him. The victim feared for his life. This was not a petty theft. This was a violent, pre-planned robbery. He deserves the fullest weight of law. Justice demands it. Prosecutor says, nobody should walk into a store, point a gun at an innocent man, and walk away with thousands. Jason Miller did that, and now he must face the consequences. Defense attorney says, this is a man with no criminal record. There is no footage of his face. No weapon recovered. No DNA at the scene. You cannot convict based on assumptions and partial evidence. Reasonable doubt exists, and the law demands we honor that. Jury deliberation occurs. Skip to result, clerk says, has the jury reached a verdict? Foreperson says, we have, Your Honor. Judge says, please read it. Foreperson says, we find the defendant, Jason Miller, guilty of armed robbery in the first degree. Judge says, Mr. Miller, you have been found guilty by a jury of your peers. You threatened a man's life and violated the safety of this community. You showed no remorse. Judge says, I am sentencing you to 18 years in state prison without the possibility of parole. Judge says, you must be given the maximum punishment. Judge says, court is adjourned. Clerk says, all rise.